Unit 10, Sales Contracts and Practices. Learning Objectives. When you have completed this unit, you will be able to accomplish the following. Recall the various terms for a sales contract and the North Carolina Real Estate Commission's requirements for its content and formation, as well as the impact of the Uniform Electronic Transactions Act on contracts. Identify critical paragraphs in the NCBA NCOR2T offer to purchase and contract. Explain their significance to buyers and sellers and the purpose of various standard addenda forms. Describe the process of delivering offers to the parties and handling modifications and counteroffers. Explain the features and uses of the installment land contract, option contract, and preemptive rights. Key terms: acceptance, backup offer, contingency, due diligence, installment land contract, mailbox rule, NCBA NCOR2T offer to purchase and contract, option, optionee, optioner, preemptive right, right of first opportunity to purchase, right of first refusal, Uniform Electronic Transaction Act. Learning Objective. Recall the various terms for a sales contract and the North Carolina Real Estate Commission's requirements for its content and formation, as well as the impact of the Uniform Electronic Transactions Act on contracts. The sales contract. A real estate sales contract sets forth all details of the agreement between a buyer and a seller for the purchase and sale of a parcel of real estate. Depending on the state or locality, this agreement may be known as an offer to purchase, a contract of purchase and sale, a purchase agreement, an earnest money agreement, buy-sell agreement, a deposit receipt, or another variation of these titles. In North Carolina, the most common title is offer to purchase and contract. The standard North Carolina Realtors forms and guidelines for completion are accessible as sample forms to real estate students through their instructors, subject to their prior written agreement with North Carolina Realtors to abide by certain restrictions, etc. The provisions in the NCBA NCOR2T offer to purchase and contract and some of the most used standard addenda will be discussed in depth later. Any pre-printed offer to purchase form offered for use by a real estate broker in North Carolina must meet the provisions and standards of Rule A-112 of the North Carolina Real Estate Commission. In addition to the 19 mandated entries of information, 2 informational provisions are prohibited in any pre-printed offer To purchase. Any discussion of brokerage compensation and any attempt to disclaim brokerage liability in connection with the transaction. The inclusion of either provision has no place in a contract between the buyer and the seller. A broker may not add either of these types of provisions, even at the instruction of a client. In practice, NCREC Rule A 112 outlines the provisions that must appear in any pre-printed offer to purchase in contract form suggested for use in North Carolina by real estate brokers. License law strictly prohibits real estate brokers from drafting sales contracts that bind other people. The NCREC does not create or approve contract forms. The contract forms used in this textbook are North Carolina Realtors Standard Forms. Realtors may obtain and use the contract forms created by North Carolina Realtors as part of their membership benefits. Non-realtors brokers may not initiate use of forms bearing only the realtor's logo. However, non-realtors brokers may obtain and use the sales contract forms and standard addenda that are jointly approved by North Carolina Realtors and the North Carolina Bar Association that bear only the NCBA logo approval through an attorney or forms vendor. Every sales contract requires at least two parties, a seller and a buyer. The same person cannot be both buyer and seller because a person cannot legally contract with himself or herself. The contract of sale is the most important document in the sale of real estate because it sets the parameters of the agreement between the buyer and the seller and establishes their legal rights and obligations. It is more important than the deed itself because the contract, in effect, dictates the contents of the deed. Issues to be addressed in a real estate sales contract are price, terms, legal description of the property, kind and condition of the title, form of deed the seller will deliver, kind of title evidence required, who will provide title evidence, and how defects in the title, if any, are to be eliminated. The contract must state all the terms of the agreement and spell out all contingencies or conditions. In situations where a contract is vague or ambiguous in its terms and one party sues the other based on one of these terms, the courts may refuse to enforce a contract for the parties. The real estate broker must be aware that the responsibilities and legal rights of the parties to a sale are governed by the terms of the contract that must be adequately prepared. Contracts in writing. The Statute of Frauds provides that no action may be brought on any contract for the sale of real estate unless the contract is in writing and signed by the parties to be bound by the agreement. The NCBA, NCR2T offer to purchase in contract, therefore, must be in writing to be enforceable. The written requirement has encountered some new interpretations in recent years. In the year 2000, the General Assembly enacted North Carolina's version of the federal e-sign legislation, Uniform Electronic Transactions Act, that addresses electronic commerce, which clearly includes real estate transactions. Under the scope of this act, contracts can be created by electronic means such as email, DocuSign, and faxes. Also of major importance for the real estate industry is that under the legislation, an electronic signature is binding. The statute defines an electronic signature as an electronic sound, symbol, or process attached to or logically associated with a record and executed or adopted by a person with the intent to sign the record. Therefore, a faxed or electronic signature on an offer or contract will probably be just as effective as ink on paper. The offer and acceptance. One of the essential elements of a contract being formed was that of mutual assent or deliberate agreement. To form a valid real estate sales contract, there must be an offer made, an acceptance of that offer, and communication of the acceptance to the other party. The offer. Anyone who makes an offer to purchase property is known as the offeror, the person making the offer. Anyone who receives an offer is known as the offeree. Example: Betty signs an offer on Sam's house. Her buyer agent presents the offer to the listing agent. At this point, Betty is the offeror and Sam is the offeree. In the previous example, a contract is not yet formed. There is merely an offer to buy that has been made by an offeror to an offeree. Those preparing an offer must make certain there are no ambiguities with respect to the language or construction of the offer, because the intent of the offer is to bind the parties when it is accepted. An offer must be definite and precise in its terms. It cannot be of an illusory or deceptive nature. Mere advertisements of a property for sale do not constitute an offer, nor does the typical listing contract constitute an offer. Preliminary negotiations also do not constitute an offer. Many times an offer may contain conditions or contingencies. In other words, the offerer is saying to the offeree, "This is my offer, if the following conditions or contingencies can be met." Example: Betty, in the previous example, made her offer contingent on her ability to obtain a permit to install an in-ground pool. If zoning prohibits an in-ground pool on the property under contract, even after contract formation, Betty is relieved from the terms of the contract. The acceptance. For an offer to become a binding contract, it must be communicated to and accepted by the offeree according to the exact terms and conditions of the offer. An acceptance occurs when the offeree signs the offer without making any changes to it, thereby evidencing his acceptance and willingness to be bound by and perform all terms of the offer. If an acceptance of exact terms and conditions takes place, and that acceptance is properly communicated back to the offerer, a binding contract is formed. If the offeree changes any terms or conditions of the offer, no matter how slight or small, an acceptance does not take place. Instead, a counteroffer has been made. Any earnest money that was presented with the offer to purchase must be handled in accordance with NCREC Rule A-107. If no contract is ever formed, the full earnest money is returned to the offerer. The counteroffer. When the offeree receives the offer and makes any change to that offer, it constitutes a counteroffer, which is a rejection of the first offer. When the counteroffer takes place, the original offer cannot be revived. The offeree also cannot later reconsider and accept the original offer. It has been rejected. It no longer exists. Example: when Betty made her offer, she entered $100,000 as the purchase price. Sam changed the purchase price to $105,000 with a pen and ink change, dated and initialed the change, and signed the form as the seller. At this time, Sam becomes the offerer, making a new offer back to Betty, who is now the offeree. Once this new offer is communicated to Betty, if she accepts it by initialing and dating the change to the form, she has accepted the offer from Sam. When her acceptance is properly communicated to Sam, a contract has been formed. If Betty changes the $105,000 to $103,000 and initials and dates the change, a counteroffer has taken place. Betty is once again the offerer and Sam is once again the offeree. This process of countering the previous offer can continue for an indefinite period, until total agreement between parties has been reached. Methods of communicating offers and acceptance. There are various ways that offers and acceptance may be communicated. Probably the most common and the most acceptable way is to communicate in writing. The offerer signs the written offer and communicates it to the offeree, and the offeree signs the written offer, denoting acceptance. When the acceptance is properly communicated back to the offerer, a contract is formed. Communication of the acceptance to the offerer may be either oral, by telephone, voicemail, or in person, or by personal delivery of the written acceptance by the offeree or by another person on behalf of the offeree. Communication to either party's agent is deemed communication to that party. Traditional, special, or electronic mail are acceptable ways to communicate an offer or an acceptance. If an acceptance is placed into the mail service to the other party or that party's agent, it is considered as having been delivered when mailed, not necessarily when actually received. This is known as the mailbox rule. The parties cannot revoke the offer once the acceptance is mailed because it is now a contract. The telegraph and telegram are other means of communicating an acceptance, although they are seldom used today in the real estate business. Facsimiles are acceptable means of communicating offer and acceptance. Acceptance of an offer becomes complete, and a contract is formed when communication of acceptance is received by the offerer's communication device. This form of communicating the offer and acceptance is commonplace in the real estate business. The mailbox rule is only effective to create a contract. Termination of offers. There are several ways to terminate an offer. Termination of offers can take place if the offeree rejects the offer or creates a counteroffer. If the offeree fails to accept within the prescribed time stipulated in the offer. Within a reasonable time, if a time of acceptance is not prescribed. Prior to acceptance, if the offerer communicates a revocation of the offer, or by the death of the offerer or offeree. Learning objective. Identify critical paragraphs in the NCBA and COR2T offer to purchase and contract. Explain their significance to buyers and sellers and the purpose of various standard addenda forms. NCBA and COR offer to purchase and contract in various addenda. Major contract provisions of NCBA and COR2T offer to purchase and contract. All real estate sales contracts can address the vast array of issues related to a typical real estate sales transaction. The major contract provisions of the NCBA and COR2T offer to purchase and contract should be well understood by all North Carolina real estate brokers since it is used in the majority of all residential sales transactions in the state. The Forms Committee of the North Carolina Association of Realtors frequently amends the NCBA and COR2T as well as other forms. Brokers are advised to stay up to date on form changes and to always use the most current forms in their transactions. Brokers are not permitted to draft legal documents for others, even at the direction of a client. Brokers may fill in the blanks of preprinted legal forms. Brokers should be competent in their ability to explain the meaning of the form to buyers and sellers. The offer, the purchase, and contract is the most important document in any real estate sale, and it is imperative that it accurately reflect the entire agreement of buyer and seller. An improper contract may have substantial adverse effects on the rights and interests of the parties. North Carolina Real Estate Commission Rule A 112 requires that brokers include all required data when completing pre-printed contracts, but prohibits the inclusion of brokerage compensation or a liability disclaimer in a sales contract. Proper use of the contract forms is vital in the process of contract formation and explanation. The broker's job is to bring clarity to the transaction by explaining what each provision in the contract means. Part of bringing clarity to the process is to present the contract in the best possible light, preferably by typing and filling in all of the spaces. If a broker must write on a form, the broker should do so legibly in ink, and if a blank space does not apply to a particular transaction, enter N or none. Because the transaction is an understanding or meeting of the minds, the information should be precise. Brokers should avoid using abbreviations, acronyms, or other misunderstood terminology. Even if the offer is changed or negotiated many times, every change must be initialed and dated by both the buyer and seller. After reaching an agreement, brokers should review the contract again with all parties. Remember that the law assumes that any person signing a legal document has read and understands the contents. If a party has any questions about the legal consequences or a particular provision, the broker should advise the party to consult with an attorney. If needed for clarity purposes, when a broker has a fully valid contract, the broker may need to prepare a new form for the parties to sign. When the new contract is signed, it is important to keep that contract with the existing contract. If there is no available standard or preprinted form drafted by a North Carolina attorney for a certain type of transaction or condition, then the broker should refer the parties to their attorneys to draft appropriate language or documents. Note also that there is no standard sales contract in North Carolina. In fact, lenders, builders, and real estate firms sometimes use their own contracts. However, these contracts must conform to NCREC standards if offered for use by a broker. The NCBA and COR2TOPC meets NCREC standards, and since it is the most commonly used form in residential sales transactions in the state, is a worthwhile exercise for real estate students to find the appropriate contract clauses or provisions in the current agreement as described in the following passages. Terms and definitions. The NCBA and COR2TOPC provides a dictionary of most of the major terms utilized in the contract. With rare exception, any capitalized term found later in the contract will be a defined term from this provision. Names. It is essential to identify all the parties to the contract by their full individual names, which includes a full first and last name plus a middle initial if available, and any suffix, such as SR or JR. Spouses should be identified by individual legal names, not as Mr. and Mrs. The NCREC has little patience with a broker that uses the term owner of record to identify the property owners, because the seller's name can be easily ascertained by various sources, including the listing agent or tax records. If a party to the contract is a business entity, be sure to use the complete legal name versus a trade name. If the property to be sold is part of an estate sale, all heirs and spouses must be named individually as sellers unless one individual has the power to sell through an executed power of attorney. Although ill-advised due to potential legal liability, a buyer's agent can be named as agent for an undisclosed principal if the buyer wishes to remain anonymous. Property. A legal description of the property that would distinguish it from all other property is necessary to create an enforceable contract for sale. Street address is helpful but usually not adequate for a binding legal description. Brokers should complete all possible blanks in this section to maximize the ability to identify the property without question. Although used alone by many veteran brokers, the parcel identifier number and the tax map reference number seldom provide an adequate description. Arguably the most reliable source for the best legal description is the seller's deed that is public record. Parties also indicate whether the sale will include a manufactured home by using the checkboxes on the form. Purchase price. The amount to be paid for the property may be only slightly more material to the parties than when the amount is due and how it will be paid. The total purchase price may be comprised of several smaller amounts paid prior to settlement, such as due diligence fee, initial or additional earnest money, assumption of seller's loan, seller financing, or building deposit. Any outstanding balance is to be paid in cash at settlement. If any of the funds paid by the buyer are dishonored, the buyer will have one banking day after a written request from the seller to provide cash or immediately available funds, or the seller has the unilateral right to terminate the contract. Brokers are cautioned to make sure that the total of the amounts entered equal the offered contract amount. Earnest money. While earnest money is not an essential element of a valid contract, it is unusual for a seller to accept an offer to purchase that does not require an earnest money deposit as an indication of the buyer's good faith. An argument for a substantial deposit is that earnest money will be credited toward the purchase price if the buyer goes forward with the purchase, and it is the seller's sole and exclusive remedy for a breach by the buyer after the expiration of the due diligence period. Earnest money deposit is defined as including both initial and any additional earnest money. While initial earnest money may be paid in several ways, including personal bank check, earnest money that comes at a later date must be immediately available funds such as official bank check or wire transfer by a time is of the essence date. If the parties insist on suing each other for the earnest money, the party that loses the lawsuit will have to pay the attorney fees and legal costs of the winning party as well as the party's own expense of the suit. Example scenario, complying with client instructions. Bob, a provisional broker, met his client Steve on June 15th to write up an offer and collect the $1,500 earnest money deposit. Steve asked Bob to hold on to the earnest money check until the offer is accepted. Because there has been no acceptance of the offer and the earnest money was in the form of a check, Bob may keep custody of the earnest check, as instructed by the buyer. Example scenario, additional earnest money. Betty buyer went under contract for a home on Friday, July 1st. Betty's buyer's agent, Alice, received the check for the initial earnest money deposit on Sunday, July 3rd. The contract stated that by Friday, July 15th, an additional earnest money deposit in the amount of $20,000 would be received. On Friday, July 15th at 4 p.m., Betty contacted her buyer's agent, Alice, and informed her that the additional earnest money could be picked up because Betty had just received her new checks in the mail. Alice reminded Betty that not only did the additional earnest money need to be in before 5 p.m., but also that the seller could reject the personal check, and if that happened, Betty could be in breach of the contract. Betty met Alice at the bank to pick up cash, and at 4:59 p.m. the additional earnest money was given to the listing agent. Earnest money deposit timeline. Escrow agent. The escrow agent identified by name to hold the earnest money in trust is usually a real estate firm, a title company, or an attorney. It is tradition that the listing firm act as escrow agent, but other arrangements are not unusual. The real estate firm's name should be entered as escrow agent, not the name of the individual broker within the firm. If earnest money is paid by check, the check should be made payable to the firm serving as escrow agent with a note on the check's memo line as to the purpose of the funds. Escrow agents can sign for receipt of initial earnest money on the NCBA, NCOR2TOPC. The handling of trust money, such as earnest money, is strictly regulated by North Carolina license law and NCREC Rule 58A.0107. Earnest money must be deposited in a trust account held in an insured bank or savings and loan association legally conducting business in North Carolina within 3 banking days of contract formation. The funds can be deposited sooner if the escrow agent so chooses. The account can be interest-bearing according to the language in this paragraph. If the offer never matures into a contract, earnest money must be returned to the buyer. Once a contract is achieved, the disbursement of the earnest money is clearly determined by the terms of the NCBA. NCR2TOPC. If parties dispute how the funds should be disbursed, the escrow agent is prohibited from making an independent decision on who is to receive the funds. The only ways to resolve the disputed funds issues are parties agreeing in writing on how to disburse funds, court rules, and lawsuit, or with written 90-day notice to the parties by the escrow agent. Funds can be transferred to the clerk of Superior Court of the county in which the property is located. Effective date. The effective date, the date that contract was formed, is defined as when the last offeree to sign the offer, or to initial the last change communicates this action to the last offerer. A signed offer is still not a contract until notice of acceptance by the last party is communicated to the opposite party. Oral negotiations and/or agreements are not binding because the statute of fraud requires written contracts for the enforceable transfer of any interest in real property. Because the effective date frequently serves as the initiation of certain time periods in the contract, it is critical that all brokers can identify the effective date accurately. Due diligence fee, and due diligence period. In exchange for a negotiated due diligence fee paid directly to the seller, the buyer has the unlimited right to fully investigate the condition and allowed uses of the property to determine if the buyer wishes to consummate the purchase contract on the negotiated terms. No due diligence fee is required. The buyer has the unilateral right described to terminate the NCBA, NCR2TOPC for any reason or no reason by delivering written notice of termination to the seller no later than 5 p.m. of the expiration date of the due diligence period, time being of the essence. If the buyer proceeds to settlement, the due diligence fee will be credited toward the purchase price. If the buyer exercises the right to terminate within the due diligence period, the buyer will receive a refund of any paid earnest money deposit. The due diligence fee is generally non-refundable regardless of the outcome of the transaction, with 2 exceptions. A material breach by the seller as noted in paragraph 8 meters, or material damage or destruction of the property improvements prior to closing. The due diligence fee should not be confused with the earnest money deposit that serves as the liquidated damages. The length of the due diligence period or the amount of the fee is negotiable by the parties prior to contract formation. Language in this section states that the contract is not illusory even if no fee is required or paid. Caution should be used to allow adequate time for the completion of possible term renegotiations after the receipt of all necessary inspections and reports. The due diligence period is significantly different from the conventional option to purchase contract discussed later. Whereas a conventional option is the right to purchase by a certain date, the due diligence option is a right not to purchase by a certain date. Instead of exercising a right to opt in and create a purchase contract, the buyer under the NCBA NCOR2T offer to purchase in contract is opting out of a contract to purchase. During the period, the buyer is encouraged to secure financing and negotiate any repairs or changes in contract terms the buyer deems necessary. If the buyer and the seller cannot reach an agreement regarding repairs or terms, the buyer can give written notice to the seller that the buyer is exercising the right to terminate the contract prior to the end of the period. If the buyer does not exercise the right to terminate before the end of the period, the buyer must proceed with the purchase of the property in its current condition unless an agreement has been signed, such as the due diligence request and agreement. Settlement and settlement date. Settlement is the process of gathering all the documents and funds necessary to complete the sales transaction. This includes the deed, settlement statement, deed of trust, and other loan or conveyance documents, and closing attorney's receipt of all funds necessary to complete the transaction. While both parties may still meet together on the settlement date to bring funds and verify that the terms of the contract have been met, it is becoming more likely that some actions are completed electronically or by express mail. The buyer established the place of settlement. Should the closing take place late in the day, the attorney may not be able to record on the same day, and disbursement of funds and the buyer's ability to receive keys will not happen until after recordation of the deed. Closing. Closing is the completion of the legal process, which results in the transfer of title to the property from seller to buyer. This includes the review of the contract of sale, abstraction, certification and application for title insurance, preparation and review of accountings and various legal documents in accordance with the law. It is unlawful for any person other than an active member of the North Carolina State Bar to hold himself or herself as competent to provide legal services. Should the closing take place late in the day or on a Friday afternoon, the attorney may not be able to record on the same day. Disbursement of funds and the buyer's ability to receive keys will not happen until after the closing attorney has recorded the necessary documents at the appropriate courthouse. Should the closing not be recorded and parties agree, there is a possibility for possession before closing. Form 2A7T should be used, and insurance should be in place to protect all parties. Special assessments. Special assessments are charges that may become a lien against the property by a governmental authority for something other than taxes, or by an owners' association for something other than dues. In paragraph 6b, the buyer agrees to take the property subject to proposed special assessments which are under formal consideration, but not approved by settlement. The seller agrees to pay all confirmed special assessments that the amount can be determined by settlement. Fixtures. Items identified as fixtures in an ever-growing list automatically convey with the property if present on the property, and owned by the seller unless they are exempted in this section. It is not necessary to cross out any listed item that is not present on the property. Any item that is exempted should be clearly identified. This includes items such both traditional and smart devices, and any exclusively dedicated related equipment or remote control devices. Prior to closing, the seller shall unpair any devices that will convey from any personal property devices with which they are paired, delete personal data from, and restore all devices to factory settings. The seller is responsible for repairing any damage to the property caused by the removal of an exempted item. Personal property. No personal property, even if advertised with the property, should ever be presumed to convey as part of the sales contract unless clearly identified in this paragraph. Even though this paragraph states that any personal property will convey at no value, most lenders will not finance a contract with any entry in this paragraph. A buyer is strongly encouraged to consult his lender before including any personal property in the NCBA, NCR2TOPC. Buyer's due diligence process. An extensive, but not necessarily exhaustive, list of activities that should be performed during the due diligence period is outlined to guide the buyer in their investigation of the property. Financing and appraisal conditions should be explored and satisfied during the due diligence period. If the buyer cannot satisfy all his questions or concerns about the property during the due diligence period, the buyer can request an extension of the expiration date of the period, but there is no obligation for the seller to comply. Enough time should be allowed during the period to negotiate any repair or remediation work. Any repair agreement should be in writing and be considered in addition to the contract. It should be noted that this contract form does not have a loan or appraisal contingency. A contingency is a provision in a contract that requires a certain act to be done or a certain event to occur before the contract becomes binding. It is a condition of the contract. The buyers should explore their financing options and determine if they can obtain a loan during the due diligence period. If the buyer decides to terminate the contract during the due diligence period, a written notice of termination must be delivered to the seller prior to the expiration of the period. A buyer should heed the approved notice information that specifies what is considered an acceptable method of communication of notice. The mailbox rule does not apply for the delivery of termination of contract. The mailbox rule is only applicable to the creation of a contract. Although not required by the contract, a prudent real estate broker would obtain and retain proof of delivery of the notice. Sale, lease of existing property. Unless otherwise noted in paragraph 5, this contract is not conditioned upon the sale or lease of an existing property. Buyer's obligation to repair damage. If any damage is made to the property resulting from any activities of buyer and buyer's agents and contractors, the buyer shall not be responsible for any damage caused by accepted practices of the North Carolina Home Inspector Licensure Board or other North Carolina licensed professionals. This repair obligation shall survive any termination of this contract. An example of this would be if during an inspection, the inspector probes the siding with a screwdriver and discovers underlying wood rot on a portion of the siding. The buyer should not be obligated to repair the affected siding. Indemnity. The buyer shall indemnify and hold the seller harmless from all loss, damage, claims, suits, or costs which shall arise out of any contract, agreement, or injury to any person during the inspections and contract period out of seller's negligence or willful acts or omissions. Closing on the property is the final acceptance of the property in its existing condition. It is important for the buyer to do a final walkthrough immediately before or as near to the closing time as possible in case there is a last-minute issue that needs to be addressed. If an issue arises, the closing attorney and all parties should be notified and come to an agreement about how to proceed. Buyer representations. In this section, the buyer discloses his transactional plans and needs to the seller. The seller should be able to rely on these representations when making decisions about the offer. These representations do not automatically become conditions of the contract unless appropriate addenda are made part of the NCBA, NCR to TOPC. The buyer makes representations to the seller while purchasing a home. One of the most important points is financing and the intent to pay cash or obtain a mortgage. This includes indicating the loan type and down payment. In either case, verification of cash and loan qualification should be submitted with the offer to purchase. Material changes with respect to funding the purchase of the property that affect the terms of the contract are material facts that must be disclosed. While the contract will not be conditioned upon the sale or closing of the buyer's other property, the parties can agree to make it contingent on that. If the buyer does have a property to sell to qualify for the loan, the buyer must let the seller know the current listing condition or pending sale of the home, and the seller is strongly encouraged to obtain and review the contract on the buyer's property prior to accepting the offer. The final two representations that the buyer must attest to are receiving or not receiving the residential property disclosure and owner's association disclosure statement, and the mineral oil and gas mandatory disclosure statement. The parties are advised to consult with a North Carolina attorney prior to signing this contract if severance of mineral or oil and gas rights has occurred. Buyer obligations. The expenses and fees for which the buyer is obligated to pay are enumerated here. Proposed special assessments, loan expenses, and certain closing costs. Closing costs could include fees charged by the closing attorney for preparation of the closing disclosure, recording the deed, title insurance, and preparation of all instruments required to secure the balance of the purchase price unpaid at settlement. If the property is located where an HOA is required, this would include but not be limited to working capital contributions, membership fees, or charges for buyer's use of the common elements. The buyer also gives authorization for their lender, the party's real estate agent and closing attorney, to provide this contract to any appraiser employed by the buyer or buyer's lender and to release the buyer's closing disclosure, settlement statement, or disbursement summary to parties of this transaction. Seller representations. Seller disclosures, such as ownership, assessments, and homeowners association obligations that are required by law or are needed to satisfy buyer financing guidelines, are shared in this paragraph. Seller representations are statements of current facts that a buyer may reasonably rely upon in deciding whether to enter into the contract. Representations are made to the best of the seller's knowledge and include only facts known to the seller at the time of representation. This includes time of ownership, because if the home was recently flipped, it could affect the buyer's ability to obtain mortgage financing. The seller also must disclose if the property is subject to regulation by one or more owners' associations, and whether there is a fuel tank located on the property. Lead-based paint disclosure. Lead-based paint was used in homes until it was discovered that it posed health risks to humans, particularly children and women who are pregnant or could be pregnant. In an effort to reduce the exposure to lead-based paint, Congress enacted the Residential Lead-Based Paint Hazard Reduction Act in 1992. If a home was built prior to 1978, the lead-based paint or lead-based paint hazard addendum must be attached to the contract when selling or leasing a property. In this addendum, the seller or lessors must answer questions related to lead-based paint hazards. During the due diligence period, the buyer has the opportunity to complete a risk assessment or inspection of the property for the presence of lead-based paint or lead-based paint hazards. A buyer can waive the right to a risk assessment, and the buyer must pay for this inspection. In the disclosure, the seller must disclose if there is the presence of lead-based paint or lead-based paint hazards, as well as provide records to the buyer if available. The buyer then will acknowledge the seller's statement and any records provided. The buyer also must acknowledge that the Protect Your Family from Lead in Your Home pamphlet was provided. And lastly, the buyer must indicate if they accept the opportunity to inspect for lead-based paint during the due diligence period, or if they decline an inspection. Particularly important on this form is the acknowledgement from the agents who are parties to the transaction that the seller was informed of their obligations and is aware of their responsibility to ensure compliance. All parties, including the agents, must sign and date this form. Seller obligations. This section consolidates in one place all the duties of the seller. The seller is to provide the buyer with title information, access to the property with working utilities, premises free of garbage, lien waivers, a general warranty deed, negotiated seller concessions, and paid confirmed assessments. If the seller commits a material breach to the contract and the buyer decides to terminate the contract, the seller must refund all earnest money and the due diligence fee and reimburse the buyer for reasonable costs incurred in good faith during the due diligence period. If the possibility exists that the contract terms will result in a short sale situation, the seller is strongly encouraged to make the lien holder's approval a condition of the contract by attaching a completed short sale addendum. Access to the property. The seller must provide access to the property during the contract term for due diligence to be properly investigated. This includes the seller keeping the utilities on during the entire contract up until the day of closing, and the final walkthrough has been completed. Not providing utilities to the buyer is considered a breach of contract by the seller. This is particularly important to remember when the home is vacant, and the seller no longer sees the need to continue paying. Removal of seller's property. The seller must remove, by the date of possession of the buyer, all personal property that is not included in the purchase. This includes any garbage, trash, and debris that the seller no longer wants in the attics, basements, living space, or outbuildings. Affidavit and indemnification agreement. The seller must provide its settlement an affidavit or indemnification agreement executed by the seller and any person or entity who performed or furnished labor, services, materials, or rental equipment to the property within 120 days prior to settlement. This would also include anyone who may be entitled to liens on the property because of unpaid bills. Owners Association fees, charges. If the property is subject to an owners association, the seller will pay fees incurred by seller in completing the residential property and owners association disclosure statement, and resale or other certificates related to a proposed sale of the property. Fees required for confirming seller's account payment information on owners association dues or assessments for payment or proration, including any expedite fee permitted under NC, Gen. Stat. SS 47 Fahrenheit 3-102 that is charged in connection with providing such information. Any fees charged for transferring or updating ownership records of the association, and any fees other than those fees specifically required to be paid by buyer under paragraph 9. The buyer will pay charges for providing information required by buyer's lender, charges for working capital contributions, membership fees, or charges imposed for buyer's use of the common elements or services provided to buyer in connection with buyer taking possession of the property, such as move-in fees, and charges for determining restrictive covenant compliance. Late listing penalties. If there are any late listing penalties associated with the property, they shall be paid by the seller. Negotiated repairs, improvements. Negotiated repairs, improvements shall be made in a good and workmanlike manner, and buyer shall have the right to verify prior to settlement. Good and workmanlike manners should be understood as the work has been completed to the standard of the industry. Prorations and adjustments. Unless otherwise agreed upon, the seller shall be responsible for the prorated amounts of ad valorem taxes and recurring governmental service fees, and the real property taxes shall be prorated on a 365-day calendar year. Any personal property taxes shall be paid for by the seller unless the personal property is to be conveyed to the buyer, and in that case, the personal property taxes shall be prorated on a calendar year. Home warranty. If the seller is providing a home warranty, the parameters are addressed. Condition of the property at closing, risk of loss. These paragraphs work together to ensure that the buyer receives the property in the same or better condition as when the contract was created. Both paragraphs survive the expiration of the due diligence period and remain binding through closing. Delay in settlement, closing. Although the settlement date is set in a different section of the NCBA, NCOR 2TOPC, there are many things that conspire to delay the actual completion of settlement. The use of time is of the essence in regard to the settlement date is discouraged because it might have an unanticipated adverse effect on the parties. Consequently, the NCBA, NCOR 2TOPC has limited the time parameters for a reasonable time after the stated settlement date to a 7-day grace period that the non-delaying party agrees to wait for the delaying party to close the transaction. On the 7th day after the stated contract settlement date, the non-delaying party has the unilateral right to terminate the contract and enforce any legal remedies for the breach of the contract by the delaying party. Possession. Possession of the property is to be delivered at closing due to reasons that include insurability issues. If the buyer will take possession prior to closing or the seller will retain possession after closing, the execution and attachment of the appropriately named addendum to the NCBA, NCOR 2TOPC is strongly recommended. If a seller does not give up possession at closing, or if a buyer takes possession before closing, there may be issues with the homeowner's insurance coverage. Because the person in possession does not own the property, homeowner's insurance would not be appropriate. This could mean that the property could be uninsured until after closing. Not only does this pose a problem with the insurance coverage, but if the house does not close on time or at all, it could turn into a renter-landlord situation and not be as clear as once hoped. Brokers should remind the seller and buyer to speak with an attorney to understand all of the legal implications. Other provisions and conditions. Because brokers are prohibited from drafting legal contract clauses or addenda, the use of other NCBA and COR addenda is highly recommended. A section of the NCBA NCOR 2TOPC lists all the standard addenda that could be attached. All checked addenda and subsequently ratified ancillary agreements between the parties, such as a repair agreement, are part of the contract and must be provided to both parties plus the lender and settlement attorney. Assignments. Without written consent of all parties except in connection with a deferred exchange, the contract may not be assigned. If all parties are in agreement, then the contract is binding on the assignee and assignee's heirs and successors. Tax-deferred exchange. If either or both parties may be considering entering into a tax-free exchange of like-kind property in connection with the property, consultation with qualified attorneys or tax advisors is recommended. Parties. The contract is binding upon the buyer and seller, heirs, successors, and assigns. Survival. If the parties in the contract make an agreement noted in the contract or addendums attached, post-closing, those considerations must be kept. Entire agreement. The parties agree to the entire agreement contained and expressed in the contract. All changes must be in writing and signed by all parties. This contract does not have any effect on a listing or buyer agency contract between the buyer or seller. Conduct of transaction. The parties agree that any action between them relating to the transaction contemplated by this contract may be conducted by electronic means, including signing of this contract. Any written communication may be sent to any mailing address or email address in the notice information section. Delivery of any notice to a party via means of electronic transmission shall be deemed complete at the time the sender performs the final act to send the transmission. Execution. This contract may be signed in multiple originals or counterparts, all of which together constitute one and the same instrument. Computation of days, time of day. Unless otherwise provided, for purposes of this contract, term days shall mean consecutive calendar days, including Saturdays, Sundays, and holidays, whether federal, state, local, or religious. The calculating of days shall begin the following day upon which any act or notice was performed or made. Time and days refer to the time and or day in the state of North Carolina. Remedies for breach by buyer. In the event of material breach of this contract by the buyer, the seller shall be entitled to any earnest money deposit and any due diligence fee which together shall serve as liquidated damages. This is the seller's sole and exclusive remedy for breach, without limiting seller's rights under paragraphs 4 and 4. Remedies for breach by seller. In the event of material breach of this contract by the seller, if buyer elects to terminate this contract as a result of such breach, buyer shall be entitled to the return of both the earnest money deposit and due diligence fee, together with the reasonable costs actually incurred by the buyer in connection with buyer's due diligence. Attorney's fees. If legal proceedings are brought by buyer and seller against the other to collect the earnest money deposit, due diligence fee, or due diligence costs, the parties agree that a party shall be entitled to recover reasonable attorney's fees. Note: a party seeking recovery of attorney's fees must first give written notice to the other party that they have 5 days from the mailing of the notice to pay the outstanding amount without the attorney's fees. Signature and dates with wire fraud warning. The offer shall become a binding contract on the effective date. Effective date in this situation means when all parties have signed. Brokers should not provide wiring instructions, but should educate parties to a transaction about best practices to avoid wire fraud. Notice information. Entry of any buyer or seller contact information in the notice information section authorizes communication directly to a party rather than the standard practice of communicating through the agents. Enter the names of individual listing and selling brokers, their license numbers, firm names and license numbers, and check appropriate agency representation boxes. Listing agent acknowledgement of receipt of due diligence fee. This section should be completed if any due diligence fee is delivered to the listing agent or an authorized agent of the listing firm. Seller acknowledgement of receipt of due diligence fee. This section should be completed if any due diligence fee is delivered to the seller. Even if the fee was signed for by the listing agent or listing firm, the seller should still sign. Escrow acknowledgement of initial earnest money deposit. This section should be completed if any earnest money is given to the firm. The firm should be the same as indicated as escrow agent in paragraph 1. If the escrow agent named is unable or unwilling to serve in this capacity, the name should be replaced with the name of the substitute escrow agent agreeable to both buyer and seller, with the change initialed and dated by both parties. Escrow acknowledgement of earnest money deposit. This section should be completed if any earnest money is given to the firm. The firm should be the same as indicated as escrow agent in paragraph 1. If the escrow agent named is unable or unwilling to serve in this capacity, the name should be replaced with the name of the substitute escrow agent agreeable to both buyer and seller, with the change initialed and dated by both parties. NCBA, NCOR Addenda. Numerous NCBA, NCOR Addenda have been approved for use with the NCBA, NCOR 2T offer to purchase and contract when appropriate. While the 2T form is appropriate for cash or financed residential purposes, it can be customized by the use of addenda. These addenda address specific issues that may be too complicated to include in the space allowed for other provisions. The broker should use approved addenda when dealing with these issues because they increase the chances of proper preparation and negate any suspicion that the broker may be illegally practicing law by drafting a contract. Note that in an event of a conflict between information in an addendum and the contract, the addendum will control, unless the conflict involves the description of the property or the identity of the buyer or seller, in which case the contract will control. Addenda forms approved by North Carolina Realtors and NCBA. In order for a buyer to hold a secondary contract position after the primary contract, the secondary buyer must have a fully executed contract with the seller. This would include the offer to purchase in contract with the backup contract addendum. An offer to purchase in contract with backup contract addendum signed only by the buyer is not sufficient. Both parties must sign in order for the buyer to hold a backup position. 2A1T Backup Contract Addendum. 2A3T New Construction Addendum. 2A4T FHI via Financing Addendum. 2A5T Seller Financing Addendum. 2A6T Loan Assumption Addendum. 2A7T Buyer Possession Before Closing Agreement Addendum. 2A8T Seller Possession After Closing Agreement Addendum. 2A9T Lead-Based Paint or Lead-Based Paint Hazard Addendum. 2A11T Additional Provisions Addendum. 2A12T Owners Association Disclosure and Addendum for Properties Exempt from Residential Property Disclosure Statement. 2A13T Vacation Rental Addendum. 2A14T Short Sale Addendum. FHA via Financing Addendum. If the buyer will be using either FHA insured or VA guaranteed mortgage loans to purchase the property, this addendum is required. The addendum allows the borrower to terminate the NCBA, NCOR2TOPC without forfeiture of any monies if the property does not appraise for at least the purchase price specified in the NCBA, NCOR2TOPC. Buyer Possession Before Closing Agreement Addendum. If the buyer will be allowed to take possession of the property prior to closing, this addendum will address many issues that might arise. Among other things, the provisions of this agreement address rent, pets, insurance, and responsibility for payment of expenses, utilities, repairs, and maintenance. This agreement is not to be used for possession for longer than 14 days nor in connection with a lease purchase or lease option contract. The agreement wisely suggests that possession not be granted until the due diligence period has expired. Seller Possession After Closing Agreement Addendum. If the seller wishes to retain possession of the property after closing, this agreement will serve in a similar manner to the previous addendum for buyer possession. Lead-Based Paint or Lead-Based Paint Hazard Addendum. Under the federal disclosure requirements of the Residential Lead-Based Paint Hazard Reduction Act of 1992, a residential seller must disclose what she knows about the presence of lead-based paint in the property and must provide any known reports about lead-based paint hazards in the property. When coupled with delivery of the EPA pamphlet about the hazards of lead poisoning, this addendum meets the disclosure requirements of the Federal Act and should be completed and signed by the seller as part of the listing process. The listing agent must initial on the second page that the seller has been advised of her obligations to comply with the Act. The buyer may utilize or waiver a 10-day risk assessment period to determine the buyer's willingness to proceed with the purchase of the property. Violations of the lead-based paint disclosure law in North Carolina can result in fines up to $32,500 per day under EPA sanctions. Additional Provisions Addendum. Probably one of the most used addenda, this form addresses 5 separate contract concerns. One provision allows the offeror to implement an automatic expiration date and time for the attached NCBA and COR2T offer to purchase and contract. Another provision allows the buyer to secure the seller's assistance in testing the property to determine if an adequate septic system can be installed or modified for the buyer's specific needs. If the property is currently subject to leases, the third provision requires all lease-related documentation to be given to the buyer for review during the due diligence period. The fourth provision would request repair or improvement projects that are known prior to contract formation. The fifth provision asks for the identifying information for any manufactured housing that will be included in the transaction. Owners Association Disclosure and Addendum for Properties Exempt from Residential Property Disclosure Statement. The seller is mandated to provide this completed addendum in transactions where the property to be conveyed is subject to an owners association, but is exempt from compliance with the North Carolina Residential Property Disclosure Act. The most common exempt transactions would include unimproved real estate, first sale of a dwelling never inhabited, lease purchase, and bank-owned foreclosures. This form discloses what services the association dues provide, the contact person for the association, and any known pending litigation that involves the association. Vacation Rental Addendum. This addendum should be used with any property that is subject to the North Carolina Vacation Rental Act. Short Sale Addendum. If the transaction is subject to a short sale approval by the seller's lien holder, this very informative addendum should be used. This form allows both parties to terminate the NCBA and COR2TOPC under certain circumstances. The due diligence period and settlement dates are automatically tied to the seller's notice of the lien holder's approval for the transaction. The form also addresses whether the property owner has known bankruptcy or foreclosure issues. A review of the most commonly used standard addenda will familiarize brokers with proper legal language for many of the recurring issues in a real estate sales transaction. These forms are available to real estate students through their instructors. Backup contract addendum. Although a property is under contract, there is frequently a chance that the transaction will not close due to any of multiple reasons. The primary buyer could exercise the right to terminate the contract during the due diligence period. The buyer financing might fall through, or the seller and the buyer cannot agree to repair negotiations. Consequently, the seller may wish to continue to market the property and encourage backup offers until the primary contract actually closes. A subsequent buyer may be interested in waiting in a secondary contract position to see what transpires during the due diligence period in the primary contract. The backup contract addendum language automatically makes the secondary contract null and void if the primary contract closes or upon reaching a named date, whichever occurs first. The secondary contract moves to the primary position upon notification to the secondary buyer that the primary contract is terminated. Written proof of primary contract termination is required. The backup buyer must close on the property within a specified number of days after notification of primary position, or the settlement date noted in the backup contract, whichever is later. Any time prior to being notified of being in primary position, the secondary buyer may terminate the backup contract by delivering written notice to the seller. In practice, many licensees become members of the North Carolina Association of Realtors, and thus have access to numerous other contract-related forms that they may utilize to deal with matters such as repair requests, negotiations, termination of contract, etc. Licensees who are not realtors need to have an attorney prepare any contract-related forms provided by the licensee to the parties if the content of the document will affect the parties' legal rights. Here are 2 true or false statements to check your comprehension. 1. The 2T offer to purchase in contract states that large screen TVs and draperies are fixtures. False. 2. The term time is of the essence is used to characterize the due diligence date and time in the 2T contract form. True. Learning objective. Describe the process of delivering offers to the parties and handling modifications and counteroffers. Submitting and handling offers. Submitting offers to seller. Real estate brokers are obligated by license law and Commission Rule A 106 to disclose all offers to sellers immediately, but no later than 3 days from the date of the offer. Offers must be presented even if the property is under contract. A broker is not allowed to hold onto an offer while negotiating compensation. Simply telephoning the offeree with the terms of an offer is not sufficient delivery, according to the NCREC 2008-2009 update course material. Furthermore, listing agents must disclose any additional information they know that may affect a seller's decision to accept an offer. This includes information about the offeror's financial ability to close the transaction, as well as the possibility of other offers that may be presented shortly. A listing agent can neither reject nor accept an offer on behalf of a seller, nor can a listing agent screen offers presenting only those offers that the agent feels have merit. All offers, written or verbal, must be communicated to the seller. It is up to the seller to accept or reject any offer that is made, however unreasonable that offer is. Brokers also must present those offers that may be at a disadvantage to them. Example: one buyer may offer the seller $290,000 in cash for the seller's home, while another buyer offers the seller $295,000 contingent on obtaining financing. The listing agent must present both offers as soon as possible, even though if the seller accepts the first offer, it will mean a smaller commission for the agent. Handling multiple offers. Brokers may experience the phenomenon of multiple offers in a hot market. If multiple offers arrive at the listing agent's office before the agent has the opportunity to present any offer, the agent should try to present all offers at the same time to the seller. Again, all offers must be presented. In a multiple offer situation, a seller can elect to work only with one offer, or if the seller does not find any offer acceptable, the seller may ask some or all the prospective buyers to submit their highest and best offers. It is the seller who must make that decision, not the listing agent. If the seller calls for highest and best offers, the listing agent should advise all buyers they can submit a new offer or stand by their original offer. Contrary to what some buyers and brokers believe, sellers are not committed to dealing with the first offer before considering others. In other words, in multiple offer situations, there is no priority to one offer over another. A seller is not bound to consider offers in the order in which they were received, even if they are full price or exceed full price without concessions. A listing agent can assist the seller in reviewing the different terms in order to choose the best offer for that particular seller. Once an offer is accepted, the seller may consider a backup offer. In a multiple bid situation, buyer brokers often inquire about the terms of other offers. However, shopping offers, a practice in which a home seller's real estate agent discloses prices and terms of an offer to competing buyers in an effort to get higher bids, is strictly prohibited. Commission Rule A 115 prohibits brokers from sharing the price or other material terms and offers with competing parties without the express authority of the offering party. Generally, there is no advantage to a buyer in sharing their offer's terms with competing buyers. Occasionally, a buyer agent asks to be present when an offer is presented. A listing agent should discuss such a request with the seller and allow the seller to make that decision. The presence of multiple offers is not a material fact, and a broker is not required to disclose a multiple offer situation unless they have permission from the seller to share such information. This is also in accordance with the Realtor's Code of Ethics. Realtor members will obtain a seller's consent in response to inquiries from buyers or cooperating brokers before disclosing the existence of other offers. Handling offer-to-purchase modifications and counteroffers. Frequently, a seller wants certain changes to be made to an offer before accepting it. For example, instead of a $1,000 earnest money deposit, the seller may demand a $5,000 earnest money deposit. As discussed earlier, once the offeree makes any material change in the offeree has rejected that offer and created a counteroffer. No contract has been formed at this stage. It is up to the original offeror to accept or reject the counteroffer. If the original offerer accepts the counteroffer with a few changes, another counteroffer has been created and the process begins again. Negotiations between a buyer and seller may consist of a series of counteroffers before final terms are agreed on. Any changes to the original offer must be made in writing and initialed by both parties. Unfortunately, if all the changes are written into the initial offer form, the contract can become virtually unreadable. It is a good idea for the broker to fill in a new standard form with the final terms and have both parties sign and date it. This avoids later confusion over which terms were changed and how. According to Commission Rule A 108, a broker needs to retain all offers, even if rejected or replaced. Response to buyer's offer. An alternative to making pen and ink changes to the original offer is for the seller to utilize the North Carolina Association of Realtors response to buyer's offer. The form allows the seller to list terms that would be more acceptable and suggest the buyer consider them when revising the original offer. The response form rejects the original offer but does not create a counteroffer. This allows the seller to remain free to accept any new offers while the original offeror is deciding how to proceed with negotiations. This form is also an excellent way to respond to multiple offers simultaneously without binding the seller to any one offer. The fact that there are multiple offers on a property is not considered a material fact that must be disclosed. However, if one of the offering parties is notified of the existence of a competing offer, then all offering parties must receive the same notification. This maintains a level playing field for all offerers. NCREC Rule A 115 prohibits any broker from disclosing the price or any other material term in any offer to purchase, sell, lease, rent, or option real property to a competing party without the express authority of the offerer. Shopping the offer by brokers has long been considered unethical and is now also illegal in North Carolina. Of course, unlicensed principals in the transaction are not bound by this NCREC rule. Handling earnest money and due diligence fee. Earnest money and due diligence fees are not required to form a binding contract in North Carolina. They are negotiable amounts, if any, between buyer and seller. If earnest money is negotiated, it will be deposited by the buyer with an escrow agent identified in the contract to evidence the buyer's good faith. Often, the escrow agent is a real estate company, an attorney, or a title company. The delivery date of the earnest money to the escrow agent is indicated in the sales contract. The NCBA Standard Form 2T indicates the due diligence fee, if any, is paid by buyer to seller with the contract for the buyer's right to terminate the contract for any reason or no reason during the due diligence period. The due diligence fee will be paid directly to the seller. If the buyer follows through with the terms of the contract, then both the amounts of earnest money and due diligence fee will be credited to the buyer at closing. The seller would see a debit of the amount of due diligence fee. If the buyer cancels before the due diligence period, the buyer is entitled to receive the earnest money back, and the seller keeps the due diligence fee. If the buyer cancels after the due diligence period, the seller is entitled to both the earnest money and the due diligence fee. The due diligence fee is non-refundable except in the event of a material breach of the contract by the seller or if the property is destroyed before closing. If the seller materially breaches the contract, the buyer is entitled to receive the earnest money back as well. Furnishing copies of offers and contracts to buyer and seller. According to Commission Rule A-106, real estate brokers must provide all parties with a copy of any instrument they sign at the time of execution, or no later than 3 days after execution. It is important to remember that a contract may have been created long before the offeror receives a written copy of the signed contract. While the rule requires that all parties be provided a copy of various instruments, understand that only one contract signed by all parties is required to form a legally valid enforceable contract. Example: when a buyer signs an offer to purchase, the broker must immediately provide the buyer with a copy of that offer. Then, if the seller signs the offer, the broker must immediately provide the seller with a copy of that signed offer. And of course, the broker also must give a copy of the NCBA NCOR 2T offer to purchase and contract, with both signatures, to the buyer. Per the rule, the word immediately has its common meaning, with the outside limit being no later than 3 days from execution. It used to be standard practice to create 6 copies of the forms, sometimes called counterparts. 1 copy went to each of the following: the buyer, seller, listing real estate office, selling real estate office, closing attorney, and lender. Only 1 signed original was necessary to create a contract. This process is no longer standard practice. Here are 2 true or false statements to check your understanding. 1. An offer becomes a binding contract when the offeree accepts the exact terms and conditions of the offer, and the acceptance is properly communicated back to the offerer. The correct answer is true. 2. The original offer can be revived if there is a counteroffer. The correct answer is false. Learning objective. Explain the features and uses of the installment land contract, option contract, and preemptive rights. Installment land contract. A real estate sale can be made under an installment land contract, sometimes called a land contract, land sales contract, or contract or agreement for deed. An installment land contract is not only a sales contract, but also a financing instrument. The seller agrees to owner financing with some type of installment payment method for the buyer. Under an installment land contract, the seller, also known as the vendor, retains legal title, while the buyer, known as the vendee, secures possession of an equitable interest in the property. The buyer holds equitable title, and the contract is a cloud on the seller's title. The buyer usually agrees to give the seller a down payment and pay regular monthly installments of principal and interest over a number of years. The buyer also agrees to pay real estate taxes, assessments, homeowner dues, insurance premiums, repairs, and upkeep on the property. While the buyer obtains possession when the contract is signed by both parties, the seller does not execute and deliver a deed to the buyer until the final payment has been made and all the terms of the contract have been satisfied. Advantages and disadvantages. For the seller, the typical installment land contract is advantageous to the seller for a number of reasons. There is an income tax benefit that comes from receiving the sales price in installments over several years instead of in a lump sum. The seller gets to retain legal title, which makes the seller feel more secure. If the buyer defaults, many land contracts provide forfeiture as a remedy. Forfeiture means that all the monthly payments the buyer has made are forfeited, as well as all rights in the property. Finally, the land contract may be the only way to make property desirable or attainable to buyers when interest rates are high or institutional loans are hard to obtain. On the other hand, sellers often receive small down payments under a land contract, and a seller may prefer to be cashed out, that is, to get immediate cash for the equity. For example, the seller may need cash to make a down payment on a new home. For the buyer, if the buyer has a poor credit rating, a history of foreclosures, or bankruptcies, or marginal income, a land contract may be the only way to finance a transaction. The down payment and the closing costs are usually lower than in institutional financing arrangements. The purchaser also has the tax advantages that come with ownership of real estate. If the property being purchased is income-producing property, profit from the property itself can help finance the purchase, such as rent collected from a finance department building providing the monthly loan payment. All these are obvious advantages for the buyer. However, if the buyer defaults under a land contract, the forfeiture remedy available to the seller is extremely harsh for the buyer. The buyer can lose all the payments made under the land contract in addition to the property itself. Also, because the buyer does not get legal title to the property until the end of the contract term, the buyer will find it virtually impossible to use the property as collateral for interim financing needs. It is also possible that the seller may have encumbered the title during the term of the contract. There is no standard approved form for an installment land contract, and it is never appropriate to use the standard Form 2T for an installment land contract. Therefore, all interested parties should consult an attorney for advice and drafting expertise. All installment land contracts must be in writing to be valid and enforceable, as required by the Statute of Frauds, and must be recorded, as required by the Connor Act. As of October 2011, North Carolina state law governs any installment land contract that will convey property that will be used as the primary residence of the buyer. This application would include a 1 to 4 family dwelling structure, or if the buyer's principal residence manufactured home will be placed on the property. The minimum contents of a North Carolina contract for deed are enumerated in the section below. As noted in the 211,201 NCREC's BICAR course, the buyer has 3 business days to cancel the contract following execution or receipt of the contract, whichever is later. The statute requires the seller to record the contract for deed or a memorandum of the contract within 5 business days of execution. The seller must allow the buyer at least 30 days to cure any default. Required provisions. Per NCGS 47H2, installment land contracts must contain the following 17 provisions: the full names and addresses of all the parties to the contract, the date the contract is signed by each party, a legal description and the physical address of the property conveyed, the sales price of the property conveyed, any charges or fees for services included in the contract separate from the sale price, the amount of the purchaser's down payment, the principal balance owed by the purchaser, which is the sum of the amounts stated in subdivisions, provisions and of this subsection, less the amount stated in subdivision of this subsection, the amount and due date of each installment payment and the total number of installment payments, the interest rate on the unpaid balance, if any, and the method of determining the interest rate, a conspicuous statement of any pending order of any public agency, or other matters of public record adversely affecting the property, provided the seller has actual knowledge of the pending order or matter, a statement of the rights of the purchaser to cure a default, a statement setting forth the obligation of each party who is responsible for making repairs to the property or paying of taxes, hazard insurance premiums, flood insurance premiums, homeowner association dues, and other charges against the property from the date of the contract. A provision that the purchaser has the right to accelerate or prepay any installment payments without penalty, unless the property is encumbered by a deed of trust is permitted by GS 47H6, and the loan secured by the property contains a prepayment penalty, in which case the contract may specify that the purchaser will compensate the seller for the prepayment penalty. A description of conditions of the property that includes whether the property, including any structures thereon, has water, sewer, septic, and electricity service, whether the property is in a floodplain, whether anyone else has a legal interest in the property, and whether restrictive covenants prevent building or installing a dwelling. If restrictive covenants are in place that affect the property, a copy of the restrictive covenants shall be made available to the purchaser at or before the execution of the contract. A statement indicating the current amount of any real estate taxes or homeowner association dues or special assessments required to be paid on the property, and the amount of such taxes, dues, or assessments that are delinquent to the extent these amounts are not known at the time the contract is executed. A reasonable estimate shall be given. If the property being sold is encumbered by a deed of trust, mortgage, or other encumbrance evidencing or securing a monetary obligation that constitutes a lien on the property, and the seller is not a licensed general contractor within the meaning of Chapter 87 of the General Statutes, or a licensed manufactured home dealer within the meaning of Article 9A of Chapter 143 of the General Statutes, a statement of the amount of the lien, and the amount and due date, if any, of any periodic payments. A conspicuous statement in 14-point boldface type or larger, immediately above the purchaser's signature, that the purchaser has the right to cancel the contract at any time until midnight of the third business day following execution of the contract, or delivery of the contract, whichever occurs later. Option to purchase real estate. A conventional option is a contract by which an optioner gives an optionee the irrevocable right to buy or lease the owner's property at a fixed price within a stated period of time. An option to purchase has two considerations: the option fee when the option is given and the agreed-on sales price when the option is exercised. The option fee is normally non-refundable if the option is not exercised. The optionee must decide, within the specified time, either to exercise the option right or to allow the option right to expire. At the time the option is signed by the parties, the optioner does not sell, nor does the optionee buy. They merely agree that the optionee will have the right to buy, and the owner will be obligated to sell if the optionee decides to exercise the option. An option is enforceable by only one party, the optionee, making it a unilateral contract. Because the seller is prohibited from selling the property to anyone else during the option period, it would probably be in the optioner's best interest to clearly terminate the optionee's rights by using the term time as of the essence regarding the option date. If the optionee wishes to go forward with the purchase, the optionee must exercise his or her right to buy, typically in writing. Once an option has expired, the optionee no longer has the right to buy under the terms of the agreement. This is different from the due diligence period that is expressed in the NCBA, NCOR2TOPC. If the buyer is silent up through the due diligence period, the assumption is that the buyer is going forward to the purchase. To cancel the buyer's contract, the buyer would have to terminate the contract in writing prior to the expiration of the due diligence period. Thus, to exercise an option to purchase, a buyer must confirm his or her intentions in writing. To go forward with a purchase using the 2T, a buyer may remain silent. The assumption will be that the buyer is going forward with the transaction. A common application of an option is a lease that includes an option for the tenant to purchase the property. Options on commercial real estate frequently depend on the fulfillment of specific conditions, such as obtaining a zoning change or building permit. The optionee is usually obligated to exercise the option if the conditions are met. Requirements of North Carolina options. All options for real property are required to be in writing under the Statute of Frauds. Under the Connor Act, an option must be recorded to be enforceable against the claims of third parties. There is currently no standard approved option to purchase contract. If a broker has parties that desire a conventional option to purchase agreement, an attorney should be contacted to draft the appropriate contract. A broker should never attempt to create an option contract. Also, there is no standard form for a residential lease with option to purchase, and a broker must not suggest that tenants attempt to cobble together the lease and offer to purchase forms. A broker should direct the parties to enlist an attorney to draft this special type of agreement. The option should describe the manner in which the optionee will notify the optioner of the decision to exercise the option. Not only should the option spell out the terms under which the optionee can buy the property, it also should describe the major terms of the sale itself, such as the purchase price, financing terms, and type of deed that will be used to convey title. The consideration for the option also must be stated clearly. Furthermore, the option should explain whether the option fee will be applied toward the purchase price. Agreements for preemptive rights. A preemptive right gives a party the first right to purchase real property. A major difference between an option and a preemptive right is which party has the power to initiate the sale or lease. The buyer, tenant, initiates an option, while the seller, landlord, initiates an agreement for a preemptive right. There are several forms of preemptive rights, but the two most common versions are the right of first refusal and the right of first opportunity to purchase. Right of first refusal. A right of first refusal is created when a property owner promises to give the contracting party the first chance to buy the property, or to match the bona fide offer of a third party, should the owner decide to sell sometime in the future. Rights of first refusal are commonly found in leases. In a lease situation, a right of first refusal might give the tenant the right either to purchase the property, if offered for sale, or to renew the lease or lease adjoining space. In some condominiums, the association of unit owners retains the right of first refusal on any sale of a unit. Note that with a right of first refusal, the property owner does not promise to sell the property at all, merely promises that should the decision be made to sell, the other party will get the first opportunity to buy. This is different from the option, where the owner promises to sell should the optionee choose to buy. Right of first opportunity to purchase. The right of first opportunity to purchase is a preemptive right agreement that endeavors to avoid some of the vague legalities of the right of first refusal. If the property owner decides to sell the property, the seller must offer to sell the property to the party with the right of first opportunity to purchase for a designated price. The holder of the right may opt to purchase for that price or decline the offer. If the offer is declined, the seller may now sell the property for a specified period of time to a third party for the designated price. The agreement may allow the owner to sell for a percentage of the designated price. If the owner does not sell to a third party during the specified time, the process begins anew with the owner offering to sell the property to the right holder for a designated price. In practice, buyers and sellers should be referred to an attorney for preparation of an installment land contract, option contract, right of first refusal, or right of first opportunity to purchase, and advice regarding these documents. Drafting of such documents by a broker constitutes the unlawful practice of law. In practice, the forms discussed here are revised once or twice a year, usually in January or in July. Licensees who use these forms should always use the most current forms available, and should take training on the appropriate use of these forms. Here are 2 true or false questions to check your understanding. 1. An installment contract can be advantageous to the seller for tax reasons. The correct answer is true. Under an installment sale, the seller allows the buyer to make payments over time for the purchase of property, and the seller usually retains title to the property until the payments are completed. In an installment sale, the seller can spread out the recognition of capital gains over the period in which the payments are received. 2. When a buyer has an option contract, he must purchase the property within a certain period of time. The correct answer is false. In the context of real estate, an option contract is an agreement that gives the buyer the exclusive right, but not the obligation, to purchase a property within a specified period. Key point review. Real estate brokers in North Carolina can legally fill in the blanks on preprinted, standard contract forms. Real estate brokers who are not licensed attorneys may not draft legal contract language for others for compensation. If North Carolina brokers offer preprinted contract forms, they must contain the mandated 19 items enumerated in NCREC Rule 12. Brokers' compensation and liability disclaimers are prohibited from inclusion in North Carolina sales contracts. A real estate sales contract is usually accompanied by an earnest money deposit held in trust or escrow account to avoid commingling with brokers' own funds. Contains contingencies or conditions to the sale that must be stated in the contract. May provide for the purchaser's right to inspect the property during a due diligence period, and includes disclosure forms required by state law or contract terms that must be given, such as the Residential Property and Owners Association Disclosure Statement. Electronic contracting includes the Uniform Electronic Transactions Act, which has been adopted in most states and does not require electronic communication. But if it is used, the contract cannot be denied legal effect just because electronic method was used, and the signature cannot be denied legal effect just because it is an electronic format. Communication of offers and acceptance can be oral, includes phone, voicemail, or in person. Written includes traditional, special, and electronic mail. Mailbox rule, where placement of signed offer in mail to other party constitutes acceptance, or directed to the party's agent, which is the same as communicating with the principal. Termination of offers occurs if the offeree rejects the offer or creates a counteroffer, if the offer is not accepted by specified time or within reasonable time, if the offeror revokes prior to acceptance, or by death of either party. All offers must be submitted, including multiple offers. Shopping offers is prohibited. The North Carolina Realtor's response to buyer's offer form rejects the offer and lists desirable contract terms. It does not create a counteroffer. It is created primarily for use with multiple offer scenarios. In North Carolina, all parties must receive a copy of any legal instrument they sign immediately, but no later than 3 days from execution. Installment land contract is a sales contract and a financing document for owner-financed purchases. The seller's advantages include a tax benefit, earned interest, and selling feature. The buyer can overcome poor credit, and income-producing property can help pay for itself. Option to purchase is when the optionee pays an option fee to purchase time to make a decision to purchase on terms and option, or renegotiate terms before the option period expires. The seller cannot sell property to anyone else during the option period. Agreements for preemptive rights include right of first refusal and right of first opportunity to purchase.